One of the pieces of evidence at the trial was all of this testimony regarding the wood from the ladder. And as you know, the scientific reliability of certain types of evidence is often challenged by defense attorneys, and the courts have created different standards with regard to, the reliability of scientific evidence. Explain for us the issue with the wood from the ladder and how the prosecution attempted to prove their case through what they argued was, kind of airtight evidence.
The police took over Hauptmann's apartment the day of his arrest. And it wasn't until a couple of weeks later that they made this claim about one rail of the ladder having been planed down because it was only about 3 3/4 inches wide and from a floorboard, which originally had a tongue and groove, which were not present on the rail. And they said there's a missing 8-foot piece approximately of a floorboard in the attic, and it was cut down to make this little over 6.5-foot rail. Hauptmann immediately, when he heard about it, said the police must have manufactured that. There were super problems with the way this was handled, which wouldn't be handled today. Number one, the wood expert that they brought in did a visual comparison, which they don't do anymore. This would be wood DNA test to compare the rail to the piece of floorboard that was brought into court from the attic. And that's something I would like to see done today. It has never been done, but the police have kept both pieces of wood. There were other issues about it. The defense experts today would have been given access to that attic. They were never given access before or during the trial, even though they demanded it. They barely got any time to look at the wood samples in court before they had to testify. Also, today, the state expert would have had to disclose the extensive notes that he had taken pre-trial, none of which came to the defense, and many of which were inconsistent with his trial testimony.
It's interesting to me that if the police still have both pieces of wood in evidence, how and why they haven't done that wood DNA testing.
Henry Lee, who's a leading forensic expert on botany, made that recommendation in a book years ago.
About that. Well, maybe someone listening can suggest again that occur.
I am actually suggesting that again occur. We're trying to get Hauptmann posthumously exonerated. There's even worse evidence, though, that was at the trial, and that was about the corpse. When you want to compare it to today, Lindbergh, improperly being put in the charge of the investigation when he should have been a suspect, ordered the cremation of the corpse only after a partial autopsy when other experts were coming in and were volunteering to do a full autopsy. So no full autopsy was ever done on a homicide victim, which was against New Jersey protocol at the time, and would certainly be required today. So that was another problem. And beyond that, the prosecutor, and I think you would appreciate this, opened the trial by claiming that Hauptmann propped a ladder against the house, climbed up to the second floor, took the sleeping child from his crib, stuffed him in a burlap bag, and then as he was exiting out the window, dropped the child 2 stories to the mud below, cracking his skull and killing him instantly. That was the claim. During the trial, the defense said, why didn't the child cry out? So at closing argument, the prosecutor changed his theory and said instead, oh no, what really happened is he was killed in his crib, that Hauptmann had a chisel in his hand and crushed the kid's skull and strangled him, both of which were totally contrary to the medical reports of the examiner of the corpse. There was no blood found by the police on the crib, in the nursery, on the ground. The medical examiner testified in a prior proceeding that it was impossible for the skull fractures to be caused by a 2-story fall into mud. And there was no blood found in the burlap bag that they had in court that they said was used to transport the child. And the police had, and the prosecutor had, an 18-page forensic report by Squibb Laboratories, which is now Bristol Myers Squibb, that also proved that there was no blood on the child's T-shirts that the corpse was wearing, on the sleeping suit that had been separately returned that the child wore that night, or on the ground in the leaves or the dirt where the corpse was found. No blood anywhere. And yet the corpse, when it was found, was largely skeletal.
So those arguments of the prosecutor in their closing argument were not based on any facts that were testified to or brought in during the trial.
No, they were not. They found a chisel in the yard. The chisel, which he alleged was the alternate idea for the murder, and yet the chisel had no blood on it either. And they knew, the police knew also, and the prosecutor knew that it wasn't Hauptmann's chisel. It had somebody else's initials on it.
The best way to follow, subscribe, rate, or message the show is to visit njcriminalpodcast.com.